Ordered. This meeting is being held hybrid pursuant to Chapter 2 of the Acts of 2025 and is being recorded. Commissioners Royce, Stebbins, and myself are participating in today's meeting. All votes taken today will be by roll call. We have a full agenda today, and I will generally summarize. We will start with opening comments from commissioners before we proceed to staff license recommendations. There are 2 change of ownership recommendations, 20 license renewal recommendations, and 1 enforcement action. There are 6 items in the commission discussion and votes section today. 3-day commence operations waiting period update, delegation of acting commission chair, Chapter 10, Section 76I designation, updates on 2025 executive director goals, working group sponsor updates, and social equity program application period update. Before we begin today's agenda, I'd like to make 2 quick announcements. First, we'll be taking a 45-minute lunch break at noon. Second, please note that today's meeting will adjourn no later than 3 p.m. I'm going to ask commissioners wishing to comment or ask questions during any part of the meeting, raise their hand to be recognized. And with these initial comments, I'm going to make a beginning statement myself. I'm honored to be here with you today. After a long and difficult 2 years, I returned to the CCC with an even deeper sense of purpose and gratitude. Through the challenges, I was reminded of the resilience of this industry, the importance of the work the commissioners and staff do together for the people of Massachusetts. I look forward to meeting with the staff to hear their concerns and look forward to making more progress to improve the positive impact we can all be proud of. To the industry participants and stakeholders, you have faced tremendous hurdles as pioneers in a growing and evolving market. Yet, despite challenges in banking, licensing, and regulation, you have continued to build businesses that create jobs, generate revenue, and serve communities across the Commonwealth. My commitment is to work collaboratively with all of you, cultivators, retailers, entrepreneurs, and consumers, to advance stability, fairness, and opportunity in this industry. As I step back into this role, I see this moment not as a return, but as a new beginning. We have the chance to build bridges, repair trust, and focus on solutions that strengthen both the commission and the cannabis industry. My vision is simple, that Massachusetts remain a leader in cannabis regulation, innovation, and equity. Together, we can continue to ensure that this industry grows responsibly, reflects the diversity of our state, and remains rooted in safety and justice. I look forward to listening, collaborating, and leading with integrity as we take the next steps forward together. So thank you. And with that, I will turn it over to my colleague, Commissioner Stebbins.
Good morning. Thank you, Chair. Welcome. Just a few updates from me since our last public meeting. September 12th, Commissioner Concepcion, our Deputy General Counsel Mike Baker, and our policy analyst Callie McDonald met with Chelsea city officials to discuss social consumption in our draft regulations. Great conversations, and we had a chance to meet with a local equity retailer as well. On 9/16, the ED, the GC, and myself met with the state auditor and her team and took up the invitation that had been extended to us to meet subsequent to the state auditor's report. Additionally, the ED, Director Giancola, and I also met with Representative Dan Cahill, chair of the Joint Committee later that last Director Giancola and I met with town officials in Amherst to discuss the draft social consumption regs, truly see the success of social consumption relying on a strong partnership in collaboration with municipal officials. We also had the chance to visit with the mayor of West Springfield to hear about the rollout of cannabis licensees in that community. As most know, West Springfield was a restricted community or no town for a number of years, so we enjoyed the chance to hear firsthand from the mayor about the progress of the licensees that have opened their doors in West Springfield. Also had the opportunity to appear on Channel 22's Focus program, which is, I'm sure they could hear this, is I think going to be available on the new Channel 22 app. Had a chance. Yeah, when you're on an app, you're reaching for it. I had the chance to visit with the OS. Finally, this week, I met with Eric Goodwine, who is a new vice president at Northeastern, not Northeastern, but Northeastern Bank. Also had a call with executives at Metric with our CTIO to discuss the calls they've had with the company that manages the ABCC's outstanding accounts receivable platform. So good conversation, and Metric is working on some concept proofs to see how a platform could work for this industry. That's it.
Commissioner Roy?
Thank you, Chair. Good morning, everyone. First, I want to thank the New England Traffic Safety Association for inviting me to speak this past week about my work on Massachusetts cannabis impairment and driver's education curriculum, Shifting Gears, endorsed by the Commission in January 2023 by my cousin, that's my left. I am proud to share this curriculum. It represented the first of its kind in the nation, and now serves as a model curriculum for other states. I want to thank Fiona Moreland and Neil McNamara from our comms and digital teams for joining me. It's always a great opportunity for members of the Commission to engage with community partners who share our commitment to public safety. I also want to take a moment to acknowledge a social media post. This week, the President of the United States shared a social media post recognizing the importance of the endocannabinoid system and its role in supporting wellness, particularly for our senior citizens. I mention this with cautious optimism that this federal recognition may open doors for new research and better quality of life through science-based cannabinoid therapies. The endocannabinoid system was first recognized by scientists in the late 80s and the early 90s, and it is encouraging this important conversation now reaching broader audiences. I also had the opportunity with our executive director to meet with two banks, First Citizens and Needham Bank, who are in the cannabis space in different ways, and to learn about what they are looking for when they loan to cannabis businesses, whether ancillary or plant touching. And it was quite an eye-opener to understand this, what they look for, and made me rethink our approach to social consumption, which I'll share at the next meeting, on how we can maybe open doors in avenues to capital for these folks trying to get this license type. So just wanted to put a pin in that and flag that, more to come. Finally, I am pleased to welcome back the Commission's Chair, Shannon O'Brien. After an extended and difficult absence, we are grateful to have her back at the Commission. With her dedication and strong leadership, we look forward to moving ahead together with a renewed focus on our mission and service to the Commonwealth. Thank you so much for my time today.
Thank you. Thank you, Commissioners. Okay, being a little bit rusty, I hope you will bear with me as I get back into the routine here. So we're going to be beginning staff recommendations on changes of ownership. Christine Moriarty is going to be presenting. Did we say that Christine is, oh, there, hey, Christine, sorry.
Good morning, Madam Chair and Commissioners.
Thanks. We'll start with Eagle Eyes Transport.
Yes, first up, we have Eagle Eyes Transport Solutions, LLC, and they are seeking a change of ownership and control of one adult use license and are requesting to add one individual and one entity. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Great, thank you. Any questions or comments from my fellow commissioners? No, hearing none, I will entertain a motion. Commissioner Roy, will you make a motion to approve the recommendation of staff to change this ownership for Eagle Eyes Transport Solutions, LLC?
So moved.
Do I hear a second?
Second.
I will take a call of the roll. Chair votes aye. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Unanimous vote. The next is Nova Farms LLC, and last night in reviewing the book, I have filed a notice with the state treasurer's office. There is an appearance of a conflict, although no actual conflict. It ends up that I went to college with one of the principals at Nova Farms, so I was unaware of that before I saw that. I did make that filing with the treasurer, but I have the ability to vote without conflict. So I just want to notify people that I do not need to recuse, but I did make that filing with the treasurer's office last night. So again, Christine, if you can finish that.
Sure. The licensee here is Nova Farms LLC, and they are seeking a change of ownership and control of 4 adult use licenses and are requesting to add one individual and one entity. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Again, do the commissioners have any questions or comments on this recommendation? Hearing none, Commissioner Stebbins, I will entertain a motion to approve the change of ownership for Nova Farms LLC.
So moved.
Do I hear a second?
Second.
I will take a call of the roll. Chair votes aye. Commissioner Stebbins?
Aye.
Unanimously approved. Okay, now we will be going to the renewal licenses, and we do have a couple of those will be done individually. And I know that the first one is Apopo Therapeutics, and I believe Commissioner Stebbins, you do have a condition, but Christine, do you need to go through this one first?
No, typically we do them as a batch. So there are 17 adult use and 3 MTC renewal recommendations for the commission's consideration today.
Thank you. So you have, so Commissioner Stebbins, do you want to, we will take these as a batch, but I know that you have for one Apopo and for GAN or LLC, you have 2 sets of conditions.
Yes.
So do you want to articulate your conditions for Apopo Therapeutics?
Sure. My proposed condition for this renewal, Apopo Therapeutics, Athol Inc., MCR 140948, within 30 business days of approval of application for renewal, provide to the CCC licensing division a response and explanation of how goals were met in their diversity plan, complying with 935 CMR 500-1011C8K and 935 CMR 500-1034B. Just by way of explanation, I went through their diversity plan update. I'm a little confused by their math because I think they added in folks that they count from their positive impact plans and ADIs. So just asking if they want to make a clarification of that.
So how about this? I'll take this one individually. We'll vote on this one individually. Just so with would you like to make a motion to approve the renewal of this license with the addition of your conditions?
So moved.
Okay. Do I hear a second?
Second.
I will take a call of the roll. Chair O'Brien votes yes. Commissioner Stebbins?
Yes.
Commissioner Roy?
Aye.
And then the next one, vote unanimous to renew the license of Apopo Therapeutics and Athol. And the next one is GAN or LLC. Commissioner Stebbins, would you describe your conditions?
Sure. Thank you. This is proposed conditions for GAN or LLC, MCR 140947. My proposed condition is within 30 business days of approval of application for renewal, please report on progress and success toward goal number 1 in their positive impact plan in accordance with 935 CMR 500.1011A11 and 935 CMR 500.1034B. Just by way of explanation, this impact goal was their efforts to hire from CCC designated ADIs, not providing, I didn't see any results provided towards that goal. And this is also a good opportunity to remind people that, and licensees that as they might struggle with meeting hiring goals in their positive impact plans within ADIs, that we do have the new Equity Career Hub is a great place to go and look for candidates, folks who have already put their resumes in the system, but encourage them to do that. But again, just kind of asking them for an update on that important goal within their positive impact plan.
Okay, great. Again, I'll ask you to make a motion to approve the renewal of the license for GAN or LLC with your conditions added.
So moved.
Commissioner Roy, will you second that?
Second.
Having been moved and seconded, I'll take a call the roll. Commissioner Roy?
Aye.
Chair O'Brien votes yes. Commissioner Stebbins?
Yes.
Passed unanimously. So then we walk through licenses on this list, numbers 2, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 through 20. Just again, only because Christine or Attorney Chattopadhyay, I'm a little rusted here. Do I need to read the individual license numbers? It's just as a batch now, so we've taken those out of order. Okay. So anyway, I will, Commissioner Roy, I will entertain a motion to approve the renewal of the remaining licenses from this list.
So moved.
Commissioner Stebbins, will you second that?
Second.
Having been moved and seconded, I'll take a call to the roll. Chair O'Brien votes yes. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
The renewal licenses are granted unanimously. We're moving on to enforcement actions. How about here? Who's?
Madam Chair, we should have enforcement counsel joining us.
Yeah.
Just give me one moment.
Do we know who was teed up to?
It should be enforcement counsel Tim.
I just think that
They're asking me
things up because they do
What? Okay, so do we want to? All right. Why don't we move on and we'll wait for enforcement counsel to show up. So now we're moving to commission discussion and votes. The first thing is the 3-day commence operations waiting period. I congratulate Commissioner Roy for bringing this to our attention, that this is one of the things that we are hoping to do to provide. This is a baby step in terms of providing some relief to businesses in terms of overburdensome regulations. So this was something that was established by the previous executive director. We have found that as the industry has matured, this is not necessary. So Commissioner Roy, I don't know if you have any comments, but we can.
Yeah, no, and thank you, Chair. And I appreciate, it wasn't necessary, but thank you for the acknowledgement. It's something I have flagged publicly. As we mature and the agency matures and the industry matures, we're taking a look at regulations that no longer have utility, maybe had utility when they were established, but I think sunsetting this requirement serves all. And I don't think there's utility in it anymore. So looking forward to no longer having this requirement. So thank you.
Executive Director Irvin, do you need to opine or anything on this? I mean, this basically is just going to be a vote of the commissioners. I just don't know if you have any thoughts or input that you want to provide.
Certainly, if I may, Madam Chair, thank you. Just wanted to add a little bit of context and thank yous as well. Obviously, the INE staff through the CIE had brought this to my attention. It was discussed as well through Commissioner Roy at a previous meeting. So in looking at the past practice that was put in place by the former executive director, I did also reach out to our CAB subcommittee for public safety, community mitigation, to ensure that there were no individuals who felt that 3-day period was still necessary. I think at the beginning of the process, it appeared that the use of it was really to give communities time when there were massive lines outside of initial retailers. So reviewing that with any sort of feedback that might have come from a community perspective was very helpful. And ultimately, there was no pushback on the lifting of the 3-day. So that has been authorized to change and a bulletin is available. I don't believe that it was initially the 3-day practice was initially put forward through a commission vote. And so I believe it can be lifted without, but it's certainly open to a vote as well. And the bulletin can then go out when you're.
We'll take a vote. Again, that's what I'm saying. And I'm not sure we necessarily need to take a vote, but let's put it, let's make it. And I also, Commissioner Stebbins?
Yeah, just real quickly. And first of all, agree. We heard this a lot from the industry about why this was required. And I appreciate the ED's explanation as to why it might have been course of business early on. But I also appreciate going through the material that there was outreach to the CAB to get their opinion. We've talked about better utilization of the CAB and the folks that serve on that. So I appreciate just expressing my appreciation that we took that step as well on what is an important policy question, but certainly one that needed to get done.
Again, and I also want to thank Chief Jones because I believe that she weighed in on this as well. So thank you. Appreciate it. Anyway, I will entertain a motion, Commissioner Roy, to approve this policy.
So moved.
Commissioner Stebbins, will you second that?
Second.
We will take a call of the roll. The chair votes aye. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Chair votes aye. It is unanimously approved. And we can move now to back to the.
General, if I may.
Please. Yeah, please.
Do we need motion language? But
I think it's straightforward enough and clear for the purpose of the record that the motion's been approved.
There's no ambiguity.
Correct.
Okay, it's like the 3-day independence operations waiting period. Okay.
Okay, all right, thank you. Okay, thank you. We'll move back to enforcement actions, Boston Bud Factory. I'll turn this over to Chief Jones is going to be presenting. Okay, thank you. Okay. Yes, Attorney Gooden. Thank you. Sorry.
Thank you, Chair O'Brien, and I am joined by Chief of Investigations and Enforcement, Khaleesi Jones. Thank you. Good morning, Chair O'Brien and Commissioners. So before you, we will be presenting a proposed stipulated agreement to resolve an enforcement action relative to Boston Bud Factory, Inc., which holds 2 final commenced operations licenses. One is a marijuana retail license, license number MR 281525, and a marijuana product manufacturer license, license number MP 281397, as well as Mr. Franklin Daly, who is a person having direct or indirect control of the licenses. His agent registrations are AR 287654 and AR 287627. So as noted, for your consideration today is a proposed final order and stipulated agreement relative to Boston Bud Factory, Inc. and Mr. Franklin Daly. This matter was initiated through an unannounced inspection conducted on March 18th, 2022. The findings of that investigation are laid out with more specificity in the stipulated agreement in paragraphs 6 through 62. Following that investigation, the matter was referred to Enforcement Council staff for consideration of possible enforcement options. On February 22nd, 2024, an enforcement action was initiated through the issuance of 2 orders to show cause. One order to show cause issued to the licensee, Boston Bud Factory, and a separate order to show cause seeking revocation of agent registration to Mr. Daly. On March 24th, 2024, Boston Bud Factory and Mr. Daly, collectively the respondents in this matter, submitted a request for informal dispute resolution. We held an informal dispute resolution conference in April, and while the those initial negotiations were unsuccessful, and subsequently the respondents, Boston Bud Factory and Mr. Daly, submitted a hearing request in August of 2024. We engaged in a pre-hearing process with the respondents, and the parties also continued to simultaneously negotiate, which resulted in the proposed stipulated agreement before you today. So pursuant to the agreement, Assured neither admits or has stipulated rather to the facts of record and applicable law as laid out in the order. However, they neither admit nor deny the commission's findings. So I will go through, Boston Bud Factory has stipulated, and Mr. Daly has stipulated to the facts of record and applicable law as laid out in the order, but they neither admit nor deny the commission's findings. So I will go through the specific violations at issue here. So through the investigation, the commission has found the following violations. Violation 1, the licensee did not comply with limited access area requirements in violation of 935 CMR 500-110 subsection 4. Violation 2, the licensee engaged in prohibited advertising activities in violation of 935 CMR 500-104 4B12. Violation 3, the licensee failed to post prices and strains available for purchase in violation of 935 CMR 500-105 4A6. And the 4th violation related to Mr. Daly individually, Mr. Daly engaged in deceptive conduct in violation of 935 CMR 500-0321B and 935 CMR 500-3017. So through the proposed agreement, the parties have jointly agreed to resolve this matter through the imposition of suspensions for the licensee and Mr. Daly, as well as affirmative relief. So those terms and conditions are as follows. First, a 14-day suspension for Boston Bud Factory's retail and product manufacturing licenses. Second, a 30-day suspension for Mr. Daly's agent registrations for him individually, as well as a 12-month probationary period for both the licensee and Mr. Daly. So during that probationary period, any substantial noncompliance with any commission laws by either of the respondents during that time shall constitute full and adequate grounds for license suspension or revocation. The licensee has agreed to also submit notice to the commission at least 72 hours in advance of engaging in any brand name sponsorship or advertising. They will also restrict the use of any manufacturing equipment owned by the licensee to activities that are permitted by law and through their license. All of the respondents' agents, or all of the Boston Bud Factory's agents, rather, shall complete basic core curriculum RBT training. And Mr. Daly separately shall complete an ethics training course from an accredited provider, and notice of the completion of all of those trainings shall be provided to the commission. Additionally, failure to comply with the terms of the agreement shall result in automatic and escalating penalties, which go up to and including suspension of the associated licenses and revocation of Mr. Daly's agent registrations if they fail to comply with the terms of the stipulated agreement. So before concluding, I would like to specifically thank and recognize the efforts of our Chief of Investigations and Enforcement, Noam Jones, our Associate General Counsel, Philip Schreffler, who previously was on our team and did the bulk of the work in this matter, and all of the other investigators and investigations and enforcement staff who assisted with bringing this matter to the proposed agreement before you today. We are recommending ratification of this agreement as an appropriate resolution of the violations. Taken as a whole, the agreed periods of suspension for both the licensee and Mr. Daly, as well as the affirmative relief, we believe will ensure future compliance and represent significant deterrence for future violations. Thank you for your time and attention. I'm available for any questions.
Thank you. Do you have any additional comments, Chief, or you?
Thank you, Chair. No, I do not have any additional comments at this time. Thank you.
Commissioner Roy, do you have any questions?
Sure. Thank you, Chair. Thank you, Board of the Council. On the two suspensions that you mentioned, are those to run concurrently or separately?
Thank you, Commissioner. So pursuant to the terms of the agreement, there is a 10-day period, if this is ratified, which the licensee and Mr. Daly will submit a short-term operational plan. Once that plan is approved, and I will just note that those types of plans are somewhat routine with the commission. So if there's a shutdown plan or any period of non-operation, generally we will get those plans. So there is a 10-day period for them to supply that plan, which will talk about how to maintain appropriate inventory controls, security controls, et cetera, what staff would be responsible for that. But then following acceptance of that, yes, both the suspension for the licensee as well as the suspension for Mr. Daly would run concurrently. So the 14-day suspension will obviously end before the 30-day suspension, but those will occur at the same time. And the probationary period will also kick off at that time too.
One question I have, and I raised this again, we just got this briefing yesterday, so we're still absorbing. And as I've noted, this is the first time that I've actually, I think, voted on an enforcement action. But one of the things the state auditor said is making sure that we have consistency in terms of how we apply fines and penalties. And I know Chief Jones is very eager for us to put in place a framework or guidelines so that we are treating licensees equally. So how is this consistent with other enforcement actions that we, it's my understanding that, there was a couple of years back, there was, I guess, a diversion of 1 or 2 vapes or joints. And initially the proposed fine was $140,000. I know that was negotiated down, but how are we saying to the licensees, based on what the auditor said, that we are having consistent penalties and fines across the board?
Yeah, absolutely, Chair. So just want to kind of discuss first at the outset, kind of our intent or our goal with prosecuting any violations of our regulations, our laws. When we're addressing matters of noncompliance, our first goal is always to bring the licensee back into compliance, which we will generally be able to do through notices of deficiency, plans of correction, etc. So once we've brought them into compliance as well, we do want to look into imposing appropriate sanctions that are sufficient to deter future violations, and then also impose certain conditions, such as the affirmative relief that we have here to ensure future compliance moving forward. So in this instance, the proposed agreement was reached through confidential negotiations, through that IDR process, through continuing negotiations. There was an initial order to show cause, but I'm hesitant to get into that just in the event I don't want to prejudice anything moving forward if there is kind of continued prosecution here. But what I will say is that initial fine calculations were all consistent with our prior practices. They are somewhat similar to prior instances as well. However, in this instance, through negotiation, we're taking into consideration a number of different facts and circumstances related to the licensee, related to the individual circumstances here, related to the facts and the issues that are present in this matter, to bring what we feel is an appropriate resolution that is agreeable to both parties here. So this is a stipulated agreement between the two.
So one of the questions I raised, and I'll give you the floor in a moment. One of the questions that I raised is that we have a suspension, and the $19 an hour bud tenders, are they going to get paid? Are other people who are at a higher executive level going to continue to get paid? I would like to understand that, because the frontline workers, and we've seen in a number of different situations where the people who are at the bottom of the totem pole, who are doing their job and trying to do the right thing, and other people make decisions that have an impact on them and their livelihood and pose a risk or have committed violations. The person selling selling at the retail, making $19 an hour, they're going to pay a penalty, and they may or may not, I don't know, but how do we make sure that the people on the front lines who are making fairly above minimum wage, but not much more above minimum wage, how are they going to be protected? Are we going to allow the executives to continue to get paid during the suspension period? Is there going to be any consideration of that?
Thank you, Chair. So just first off, want to note on that, it's whenever we're taking enforcement action, I know we're cognizant of the fact that the folks or the issues that we are attempting to address through our actions, oftentimes there is kind of unintended consequences, or there are other folks that are wrapped up into this. And we are aware of that. There have been prior actions too where we've taken suspensions, and the impact on other folks that may not be implicated in the actual underlying actions that we're trying to correct is definitely front of mind for us.
But will the people who are at the top levels, who were involved in planning and obfuscating and doing this, are they going to continue to be able to take their salary, or do we look at that at all?
So when we're speaking to that or addressing that, that may be incorporated in part of the short-term operational plan that they're submitting to us. But it is just kind of a fact of the matter here. When we're resolving this issue, we're negotiating with the businesses, we're negotiating with their counsel and persons who have direct control. Unfortunately, we're not able to negotiate with everybody involved in there. So while your specific question, will Mr. Daly be able to collect a salary while he is suspended, that's not addressed as part of the terms here. But
it should be
part of that,
I believe.
I definitely hear that feedback on this as well. So it's not incorporated into this specifically. Through the period of suspension, he will not be able to be on premises. He will not be able to work for Boston Bud Factory or any other marijuana establishment or MTC. He cannot do anything that would otherwise require a valid agent registration. So he will not be working for the company. It is more of a business decision in terms of whether they feel that him not working during the period of suspension is worthy of kind of continued collection of his salary there, but that may be part.
But I take this back to who's getting punished. And I understand that this certainly a two-week suspension is not nothing. But there is no fine, and we've seen other businesses that may not have done exactly what happened here, not receiving a much more stiff penalty. So the people that I'm most worried about right now are those people who just were doing their job and they don't make that much money and they're not going to get paid for 2 weeks. Is there anything we can do to assure that those people are protected, or that anyone who was involved in that not only is not involved, but also is not continuing to get their pay, while people who are just doing their job don't?
And Chair, I mean, I can't speak to each individual agent's kind of complicity or actions in this as well, but I will just again note that as part of their short-term plan, there are folks that will need to continue working at the business to maintain security, maintain inventory, just maintain the facility generally. Even though they're suspended for 14 days, did not necessarily mean that everybody needs to go home for those 14 days. We have had in the past, when licensees are suspended, there are a number of folks that are needed to run these businesses. So,
but if we're saying someone can't work,
Mr. Daly is the only person that is being suspended in accordance with this agreement.
Right.
So any other agent for Boston.
But are we entertaining whether or not he continues to get paid while he's not working, while other people don't get paid?
Yes, I'll defer over to Chief Judge.
Yeah, if I may, Chair. What we'll do, because it's part of the plan, we will be getting a short-term plan, from the respondents. We'll look into that as well, because this is a question that has been posed here. Why I was not part of the settlement agreement? We will ensure that we look into it to make sure that during the suspension, let's look at their business decision in terms of, are they going to continue to pay him or not? So we'll make sure that we have a record of that as well. We'll review it.
Okay, all right. Commissioner Roy, do you have any additional questions?
I do. Are you allowed to talk about aggravating and mitigating circumstances?
Commissioner Roy, if it's anything to do with the facts of the case, we will not be able to get into those details as much as possible, because we want to stick to what's in the stipulated agreement. But anything related to the facts, since you're the final arbiters of this matter, in case we don't, it's a situation where the board decides, decides to, for example, let's say the board did not agree, we wouldn't want to be getting into the details of the case and prejudice.
I understand. Okay.
We don't want to prejudice.
So I won't push further about aggravating and mitigating circumstances. I do share similar concerns as the chair. And I expressed this to the team yesterday that we had another licensee with 2 pre-rolls that were classified as diversion. Here we have quantifiably more that went into an arcade machines mentioned 14 times in this stipulated agreement. And by nature, arcade machines appeal to young people. And then we also have where there was non-compliance with 500-105 4B12 about age verification at the block party located at the premises headquarters where the arcade machine is located, which again by nature appeals to young people. So, and no fines assessed here, and quantifiably more pre-rolls, if you will. And I share the concern that closing down this will hurt those most vulnerable who work there, which is the bud tenders. So I'm not going to belabor this. I just have more of a process question. So I don't know if it's to the general counsel or to the enforcement counsel. We have a binary choice here, ratify or reject. There's no remanding of this. We can't remand it and work on it more and come back to us.
I would defer to the general counsel on that question, Commissioner.
If I may.
Please.
Thank you, Madam Chair. In response to the question, this is entirely an agreement between the parties. So if it were not approved here at this point in time by the board, the parties could decide to go back and renew their discussions.
Okay.
Taking into to account some of the feedback received.
Okay. And my other question, process, and I'm just going to throw it out, whoever wants to take it.
Go ahead.
All right. So if we reject, the operation still stays in business. It's not, so they can continue to operate till we come to a place where there's an agreement. So by us rejecting this today, Boston Bud Factory continues to operate. Accurate?
Yes, that is correct.
Okay, so as I say here today, I'm inclined to reject this because I am too concerned that those most vulnerable that work there are going to be harmed the most. And also, I don't feel that it was commensurate with previous stipulated agreements. So in my one opinion, I feel this needs to be retooled in certain areas. And I would hope that the parties could come together while still operating, could come to an agreement that doesn't harm the workers, but makes sense for all. And so I'm just showing my cards. That's where I am right now.
So maybe I would entertain a motion to table.
I think we have to reject it for them to fix it.
Okay. Commissioner Stebbins,
Yeah.
do you have any questions or comments? Sorry.
I do, and thank you for your points, Chair, about, I think you hit on some interesting topics. One that I think some that we would not see until this temporary operating plan was shared with us. I don't also know whether commissioners are privy to that operating procedure.
The operating plan that they'll
Or just to see what it is.
Yeah.
Just to see what it is.
Yeah, Commissioner, I think typically that would be received by the lead investigator on this matter and reviewed. I think if the commissioners wanted to see that, I think that would be different than what we've done in the past, I would say.
If I may.
please.
I would have to defer to the GC here in this matter because that it will be part of the investigative materials. As I don't know, your final arbiters of this map, and I don't, again, not to prejudice the licensee, providing the SOPs to the commissioners or the materials related to an investigative matter, that would really be inconsistent with any other enforcement actions or investigations we've done in the past. We don't typically share the investigative materials related to the matters. So I defer to GC related to that because I'm thinking about 38. So
can I also, can you, Council, can you explain what the chief was just saying, which is we don't share investigative materials, the confidentiality, maybe you can do that, just the confidentiality. I'd like to understand that as well, just to understand how that functions.
Right, I'll defer to the GC to actually respond more to that, but the investigative materials that could either influence a decision by the board, it's always has been as part of the investigation. It's not in the best interest for us to share what those materials could be because we want to avoid influence from those decision makers, which will be the commissioners of the board in terms of how we should proceed. Because the way that it's supposed to be, the board is not supposed to be directing the investigation because at some point it will come before you for you to make a determination or a decision.
Yeah.
So for those reasons, that's why sharing any materials that are considered evidentiary, it is not in the best interest of.
And then one would have to recuse oneself. You'd have to recuse yourself
once you've done.
Right. So if you had that information, then you'd have to recuse.
Exactly.
I get that.
Right.
Okay, Chief, General Counsel, sorry.
Yeah, I will, thank you, Madam Chair. I think what the CIE has just said is entirely correct, that we have put up a wall here, and there are certain investigatory materials that it would not be appropriate to share at this time for the purposes of 30A. Should this matter come back to you for a vote at a future time, whether a hearing officer is involved. So one of the other options here is that if an agreement is not reached by the parties, they would go back before the hearing officer and we'd go through the hearing officer process. The hearing officer would issue a recommended decision and then that would come before you as well. So again, the 30A aspect here is very much alive. And so for that reason, I would caution about sharing more information than what you have before you right now.
Okay. Commissioner Stebbins?
Yeah, thank you, Chair. And just some additional points, and I think you raised this appropriately, Chair, is in terms of how we enforce these violations. I firmly believe that we haven't necessarily, in the short life of this commission, kind of built out a body of work that we could say, oh, this falls into this type of category. We've seen this type of case before. Each case is different. I think as I read through this, there was highlighted lack of cooperation or from some of the respondents in this. And obviously, we encourage, full faith, honesty in terms of helping to conduct these investigations. I did have another question, which was, and I think I've brought this up before, this is a equity licensee, I believe, in the city of Holyoke. What steps do we take to offer any notification to the city of Holyoke, just in case this trips something potentially within their HCA or anything else like that? But I certainly would like us to think through a process of notifying the local host community about what actions or steps the commission may or may not be taking.
Yeah, and Commissioner, just kind of speaking to that as well, I don't believe historically have proactively notified each host community when we resolve an action. I will note, however, though, that these agreements are public record. They are discussed at the public meeting as well. So that information is available to any municipal officials, community members, et cetera, and they can use that information for whatever purposes they would deem necessary. But in terms of kind of thinking about processes, I think we can definitely take it into consideration.
Please, Chief.
Yeah, thanks, Chair. Commissioner Stebbins, one of the things we need to keep in mind is that if it's a situation where there are any violation related to local ordinances or bylaws under 500-170 subsection 1, then the commission at that point, has to communicate with the municipalities. But as far as the settlement agreements or anything like that being something that we communicate with the host community agreement, we would need to really talk to the executive director about that to see if this is something that we want to, is something that we need to put in place or not. And also we need to also communicate with the general counsel as well, as far as that is concerned. But based on what we're talking about here, at its face, looking at the local ordinances, bylaws, anything, looking at the facts of the case, this is not something that really would have required us to have conversations, with the municipalities. So we need to be consistent with, what our regulations say.
Absolutely, and if I might,
Please.
Absolutely, and I hear that. We don't come across a lot of these, which is good that, the industry and our 600 plus operating commenced licensees operations aren't, reaching a phase like this. But, at the same time, as I read through this, there was certainly activity that was happening off our licensed premises. And again, it's not to, it isn't to offer judgment about what might or might not conflict with local ordinances, bylaws, but obviously this is a business operating within their community. And I think if we consider taking the step of at least notifying the community after a vote is taken on a stipulated agreement, and it's more to be a partner and more to just say, this is action the commission took with respect to one of our licensees. It's also an operating business within your community. I think that just is, and again, I defer to the ED or defer to all of you as to how we can do that compliant with all of our processes and procedures. But I think it is a helpful tool for that collaboration with our municipalities and hopefully making sure that events like this don't happen again.
Commissioner.
Yep, thank you.
I have to remember everybody's last names.
Mine's short, one syllable, so it's I just want to state for the record how important due process is, and we want to make sure everybody has the due process afforded to them by law. And I want to thank you for, a reminder of the 30A, which we all are mindful of. I just have a couple of thoughts and a question. Is ability to pay a mitigating circumstance And before you answer, I just want to say, I think we need to be cautious of that because we had a similar issue of non-compliance and we assessed a significant fine. And if we use ability to pay or the ability to pay defense, then that almost gives someone a license to commit non-compliance, egregious non-compliance, because there's an ability to pay defense. And we lose the hammer because it's all carrot. And so I would just caution us because everybody will waive the ability to pay defense flag if they get in a similar situation. So having said that, I thank you for all your work on this, but I think I'm hopeful that you can come back to the table. Again, mindful of the bud tenders and the workers, mindful of maybe is a 30-day suspension appropriate? I don't, so weighing all of these factors, and I just caution about the ability to pay defense because everybody's going to use it. And then they'll, and I have serious concerns about what I read in this. And I hope to never see this again, especially from this licensee. So again, I'm going to say that I'm going to reject this proposal for a number of factors. And but I don't know if you want to answer my question about is ability to pay a mitigating circumstance.
Thanks, Commissioner Roy. I think as we indicated previously, we don't want to get into the aggravating mitigating circumstances outlined in our regulations that's related to the calculation of fines. We don't want to get into any of the kind of underlying facts here and what might have gone into calculating those fines based on those aggravating mitigating circumstances. But I will say that your feedback here is definitely noted, and we will absolutely consider what you're saying here as we're moving forward as well.
Yeah. Now, if I may, please, having said that, based in regulation, we have in 500-360 an assessment of administrative fine up to $50,000. Having said that, I'm not advocating for, break the bank fines. What I'm saying is consistency matters. And, and I would, if I'm a licensee, I'm using the non-ability to pay defense to try to get out of paying a fine. So I want to see, even-handed consistency. And so the penalty fits, I don't want to say the crime because some people say I said it, but you know what I mean. I'm using that as a saying. So we just want to make sure that it's commensurate with what's happened in the past. And also that it just makes sense for the industry. So I just said my piece on that. Thank you.
Thank you. And I just want to redouble. I know that the chief is very interested in us doing a little bit more work on providing you a consistent framework. I have heard some stories of people being asked, how much money do you have in the bank? Why? Because we're going to assess you a fine that is a percentage of what you have in the bank. That's the kind of authority that has been wielded in the past. And I know that you in particular want to make sure that you have those consistent goalposts so that we are able to meet what the auditor said to us, which is making sure that we provide fair and equal treatment to all. Obviously, there can be mitigating factors, but anyway, so I will take that. So since it is clear that we don't have a quorum to approve this, I'm going to entertain a motion to reject this and then ask our staff if we could revisit this with some of the questions and concerns that we've had in mind, understanding your needs to maintain confidentiality. So I think that's appropriate. Commissioner Stebbins, I don't know if you have any thoughts, but I think that we've raised enough questions here. Again, not that you haven't done, and I know this has been a several-year slog to get through this, and I know that it predated both of you being in these roles, so I totally understand that as well. But I think that might be the best course right now is to allow the status quo, but then go back and maybe address some of the questions that the commissioners have been raising today. So I will entertain, Commissioner.
Yes, Commissioner Roy, they remain operational, but we also have to keep in mind if it happens that there's another enforcement matter investigation that could happen, that could lead to, suspension or revocation. Those things do happen sometimes.
That's right.
That's not this, but we just want to keep in mind based on what's going on right now. they will remain operational.
Say that loud, clear, repeat that again. Any additional violations? Say it again.
Local suspend, that does not impede us from doing so. So I just want to put that on the record that we're clear here that they're operational right now with the understanding of if there's any, egregious violations, then it would, that requires to do in order to show cause for suspension or revocation, the commission would have to proceed accordingly.
I think giving us a little bit more time and you a little bit more time to maybe take into consideration some of the questions you're raising, I think that could be helpful because I think that some of it's a little bit in a black box that we can't see right now. So, maybe that provides you with a little bit more guidance to, especially when it comes to this operational plan, to answer some of those questions. So does that make sense to you? All right. So I will, Commissioner Roy, I'll entertain a motion to reject this agreement as it's currently drafted. So moved. Commissioner Stebbins, will you second that motion?
Quick clarification. We looking for rejection or remand?
Yeah. I would have tabled it, but I'm told I can't table it.
Madam Chair, may I make my vote? I'm rejecting it with the hope that the parties can come back in good faith and renegotiate. And having said that, I reject it. So,
do you have any additional questions, Mr. Stebbins,
No.
or will you second that?
I will second it.
Okay, having moved and seconded, I'll call the roll. Commissioner Roy?
aye.
Commissioner Stebbins?
Aye.
Chair votes aye. It is unanimously rejected, but hopefully we can come back with the questions answered. So thank you very much. And I know this has taken years, so I appreciate that. Thank you. Okay.
Thank you.
And nothing else. Okay, so moving on to the delegation of acting commission chair. I have sponsored this, and with my return to the position of chair, there will be a number of policies and procedures, the enabling statute, understanding that we cannot go beyond the law. On September 13th, 2023, before I was suspended, my attorney and the then general counsel for the state treasurer, Sarah Kim, who is now a judge, the two of them were negotiating what was going to happen to me. It was still unknown to me. I was told that I might be suspended, and so we're negotiating a procedure that would allow for the commissioners to vote on an acting chair. That voting for the chair would supersede the strict letter of the law of Chapter 76, which allows, solely provides the authority for the chair to delegate an acting chair. On the evening of September 13th, I sent that letter. It was received by then acting general counsel, Attorney Carter. On the following day, Commissioner Roy, on September 14th, she served as acting chair. On September 18th, for some reason, she was interrupted in the middle of the meeting, told that we did not have an acting chair, did not acknowledge that there was a delegation letter. So I want to make sure that there's no confusion in the future. Even though she was the sitting secretary, and that had been the previous process that we used in the sort of hit by the bus scenario that, especially when Commissioner Hoffman precipitously left his position in April of 2022 and had not delegated an acting chair, there was an agreement that the then secretary would be delegated to be the acting chair. That did not happen. So what I'm sure is we avoid confusion in the future. For instance, as some of you may recall, the former executive director appointed our then COO to be the acting executive director. That was not consistent with state law. So as a result, the comptroller directed the commission to redo all of the paperwork and filing that had occurred when we did not have a legally appointed acting executive director. And then the commissioners had to come back and vote to appoint the CPO, Debbie Hilton Creek, to be our acting executive director. We followed the statute, but the first time the statute was not followed, which required us to redo all of the paperwork. So one of the things that I'm going to be doing today, and I'm actually not even sure whether or not this actually needs a vote, but I'm announcing it. I will be delegating. I'm putting together a standing letter delegating the authority to Commissioner Roy to be the acting chair in the event of I have some absence where I'm not able to delegate that. I want to have that standing so that there is no situation where we have two people sitting across the table looking at each other and delaying our business for days because we have an even number and can't make that vote. That also being said, I'm working with the executive director. We're going to be going to the Attorney General's office or trying to seek some sort of an opinion, because my concern is that because we have not for 2 years have an appropriately delegated acting chair, some of the votes that took place may not be valid. And so one of the things I'm hoping to do going forward is making sure that we check the boxes. Not going to be reopening things, but basically, just as we had to do with the controller's office, figuring out how we dot the I's and cross the T's. So the only person under law right now who under the statute can delegate that authority is the chair. I'm creating this standing delegation. I don't even really think I need a vote. I think it's just, and Council, I think you will agree, I do not need a vote to do this. It is solely my authority to draft that delegation letter.
If I may, Madam Chair.
Please.
I will reference the statute here. I mean, you're talking about Chapter 10, Section 76H. The language reads here, the chair shall preside at all hearings at which the chair is present and shall designate a commissioner to act as chair in the chair's absence. Really, the language there does pertain to hearings and does not go any further than that. So just as a textual matter, looking at the statute, I will caution that, looking at the text of the statute, there are some limitations there.
So what do you anticipate? So are you anticipating that in the event of any delegation, I mean, for instance, I understand that when Commissioner Concepcion was sitting in the role of acting chair, she was actually attending and running, which I'm not sure is necessarily within the bounds of this statute either. But what are you saying that the delegated authority is limited to? Because I will encompass everything, all of the delegation of authority. So what limitations are you saying are within the statute here? So you're saying that I could delegate and then someone else could be playing other roles that the chair plays?
If I may, Chair.
Yeah.
I'm just, again, relying on the statute here, which does specifically relate to hearings. I will note that the governance charter that was recently voted upon by the board does go further than that, and it gives the power to delegate for hearings and meetings.
And if I can interrupt you, I will include that. I will include that in the delegation letter, exactly what you're talking about. So, and this is also one of the other issues that we're going to have to grapple with. Neither of you were here, and frankly, I wasn't here when the governance process began. But Commissioner Stebbins, I think you and I had talked about this a number of years ago. But the fact is, when that process was begun, I know that I remember it's on videotape, the ones we can see from executive session, that both Commissioners Concepcion and Camargo, I think it was Commissioner Camargo, both stated that we are doing this, creating this charter, but it has no effect of law or regulation. It's just a policy. And we were also guaranteed at the beginning of that process, because it was not, it does not have force of law, that this would be an agreement that had to be unanimously voted upon, and that has not happened here. So anyway, we won't get into that today. I appreciate your feedback, but I'm just letting people know I will take the language from what has been drafted within the charter. I will incorporate it into my designation letter, and then I will send it to you so that we have that basically certainty that we're not going to come up with some process that doesn't meet. If someone, I just think that this is, for me, I'm more comfortable because I think that we've created a significant problem because staff undermine the authority of the chair to make that delegation. So that's what I will be doing. We don't really need to vote. Commissioner Roy, if you have any comments, I'm happy.
Yeah, I just want to cite the language for folks listening from the governance charter. Number 2, the commission chair exercises supervision and control over all affairs of the commission by serving as presiding officer at all public meetings and hearings, at which the chair is present, designating a commissioner to act as chair in the chair's absence, and making division or redivision of the work of the commission among the commissioners as the chair deems expedient. Again, all public meetings and hearings.
Okay, Executive Director?
Just looking to clarify here as well. Thank you, Madam Chair. So it sounds like the discussion that you'd like to have on the governance charter is at a later date that you would look to.
Yep.
I have one letter that I can certainly put on file that you've sent, and then I provided that same feedback that Commissioner Roy just read with input as well from the GC today, that strengthening the delegation letter so that it is more clear that it is for sort of all of the roles of the chair rather than just relying on the statute. You'll incorporate that letter, send it back, and then we'll file the updated letter.
Right. I think it really comes back to who has the authority to delegate. The treasurer doesn't have the authority to delegate except at the initial designation of a chair. And the term of the chair, the authority of the chair runs through the term of the person so designated to be chair. Once you, and I use the term power baton, once you've placed the power baton in the hand of whatever commissioner, and by the way, just because I was the appointee of the treasurer didn't mean that I necessarily was chair. That was a decision that she made, and frankly, she rejected designating other commissioners to be chair. She made that decision. So once I had the power baton, I'm the only one who can hand it off. And so that's ultimately what I think this statute says. But the other thing is, no staff person can pull that baton away from the chair and make a determination where it goes. So that's why this is going to be providing clarity. This will be providing consistency. And, again, it's really just, I'm discussing it, I'm sharing it, making sure that the public understands what I'm doing. And again, we can sort of end it there, but I don't really think we need a vote, but I'm just making sure the public knows that we will also be looking at the legal implications of that withdrawal of the power baton inappropriately on September 18th, 2023. So again, moving on to the third issue, Chapter 10, Section 76I. The statute also allows that any matter may be heard, examined, and investigated by an employee of the commission designated and assigned by the chair with the concurrence of one other commissioner. Such employee shall make a report in writing relative to the hearing, examination, and investigation of every such matter to the commission for its decision. For the purposes of hearing, examining, and investigating any such matter, such employee shall have all of the powers conferred upon a commissioner by this section. So I will be, with the concurrence of one, maybe two, commissioner, I will be designating Attorney Stephen Lodzinski to conduct an investigation into certain policies and procedures that I would like to have examined. I will ask him to make a and because this employee shall have all the powers conferred upon a commissioner, he will act as if he reports to me. He certainly is still a part of your team to general counsel, but I am exercising this authority. So I'm seeking, thank you. I'm seeking concurrence on that, Commissioner Roy.
Madam Chair, you have my concurrence.
Okay, thank you. So with that concurrence, we will move on to the next, moving on to, you do not have the floor. Moving on to the next, we're going to do updates on the executive director goal. We have the concurrence and I will move forward with that, but thank you. All right, executive director, if you could share with us your goals.
Thank you, Madam Chair. And I think obviously I have two items listed on the agenda that we had discussed to sort of give the opportunity for an update on work that has been ongoing over the last well, 6 months since I've been here, I should say. But really, some of it dates back prior to my arrival as well in March of this year. And so what we have is a document that summarizes goals that were voted in April of 2025 by the commissioners. They are 12 goals that are broken into 2 sections, and we did at that time have them available in public meeting materials, etc. So what I've been trying to do is put those goals in the context for the commissioners and for commissioner discussions on what we know to be a relatively problematic budget situation that we are currently in, and also engage in discussions as we potentially ask for supplemental funding for that budget, and if we don't get that, how we may need to prioritize these goals and other workflow. And so just really high level, and then I can certainly answer questions that are specifically at the top of mind and may need to follow up as well in the future with specific agenda items as appropriate. So goals 1 through 5 were really goals that were intended to be completed by the end of the fiscal year. These were items that were relatively ongoing when I arrived in March, and we were looking for sort of immediate action. The governance charter, which we spoke about before, was one of them that was voted on May 22nd, 2025. The FY26 budget, getting that to the finish line, I think it was my second week. I presented with Commissioner Stebbins and Commissioner Roy and the CFAO Lisa Schlegel at the joint committee, and ultimately what we received was about 33% lower than our request, which is a lot of what is discussed here in this document of how we'll adjust. Holding the first CAB meeting was set. We are looking to set a cadence with what is a very large group. And so actually I will send this document out to them for review, in that we have not been able to hit a consistent basis and reach quorum with such a large group. That has been a challenge, but we were able to meet that first meeting, introduce myself as the chair. The conclusion of Chapter 180, obviously we had a sizable update on August 14, 2025 about where we are with the host community municipal equity updates. Good discussion at that time with the commissioners, and we'll have those periodic updates as we move forward, in addition to the work that came out of that for HCAs. So 94% of the actual task list under Chapter 180 has been complete, and the remaining tasks that we have on here are really related to our need to invest in IT infrastructure, which I'll talk about in a moment. The medical use program as well, we had a goal to establish a working group, which we can talk about under the next agenda item. That group is due to provide recommendations through me to the board in the coming months. And those were really the 5 goals intended to be done in relatively short order when these were voted in April to be done by June 30th. The remaining goals, 6 through 12, are ongoing, but obviously what I have here listed are milestones, next steps, and any additional information as appropriate. So for lab testing protocols, we've had numerous administrative orders this calendar year. Admin Order 4 and 5 went into effect in April and June. We've engaged consultants with what was our available funding at the end of FY25, and those reports should be coming to you through the testing team by the end of the calendar year, potentially beginning of the next calendar year. Additionally, staff is engaged with ITLs on listening sessions and has received written feedback from the ITLs in our jurisdiction. And then the portal for the Public Health and Safety Advisory as well. So next steps are listed in here, and really ultimately what will be a very sizable and significant discussion for the commissioners end of this calendar year, early next calendar year, on how we would like to approach and how the commissioners would be in favor of approving changes to policy, protocol, or regulations. In terms of organizational culture, I've listed here quite a few things that have been done, much of which I've done in conjunction with our CPO, Debbie Hilton Creek. Excellent work that has been accomplished, but also many next steps that are listed. And then within goal number 8, we had a number of items related to not just research, but also open data. And so a pursuit, which I have done with the Chief of Research and the CFAO in terms of looking at ways that we can improve and open up our ability to receive grant funding that would support our research, is discussed in here as well, and the steps that are still underway to look at increasing our ability to receive grant funding to support our research. Obviously, again, budget being a major concern. Expansion of the open data platform, I highlight in here quite a bit of work that we've done. Really, the amount of manual work that goes into our open data platform right now can only really be addressed through improvements or replacement of our IT platforms. What we all know, the licensing platform, Mass CIP, and our medical platform, MMJOS. We have requested funding through EOTS for that MMJOS platform. And we would anticipate requesting funding for the Mass CIP through EOTS, as we have not received it in FY25 or 26 budget requests. In terms of policymaking support, I would highlight the work that's been done by our government affairs team in putting together quite a few very significant policy reports. It has been a lot going on, as we all know, federally and in the state. And so those reports are going to be extremely helpful to a number of the other working groups that we'll talk about. We've also engaged the UMass Donahue Institute as it relates to putting together the delivery exclusivity report, which will significantly enhance the policymaking support provided to commissioners as you review that report. And the vote prior to your reentry, Madam Chair, was to bring that back by January 2026.
That's okay. Question.
And that is
When you say bring it back, but January
a
2026.
report is due to you. The regs state that the report will be provided to the commissioners. At that point, you are going to review the report. You'll need to deliberate and choose the future of the exclusivity period for delivery licensees.
But when does that exclusivity? So it was my understanding that we failed to do the ongoing research. And so we had to scramble to hire an outside consultant to get it done. But I thought there was some shorter term deadline. So the commission voted to temporarily extend
To April 1st, 2026.
So it's through. Okay, great. All right. Thank you. Please, Commissioner.
Yeah, you're right. That the research the data collection should have been going on when the clock started ticking, April 1st, 2022. For whatever reason, those metrics were not collected. The data was not collected. And so they came to us for an extension, which we granted till September. Again, we're not where we need to be for whatever reason. And so now the board was asked for another extension by the folks in the group and the lead sponsor. So hopefully there's no more extensions. Like, we need to have this wrapped up so commissioners can make thoughtful and mindful decision about exclusivity in time for the April 1st deadline. So again, I don't know why this wasn't completed on time, on mission. It wasn't. And hopefully learning experience as we go into social consumption. We don't want to repeat this again. And hopefully there's no need for any more extensions moving forward. Thank you.
Thank you. Commissioner Stebbins, any comment from you? Sorry.
Nope.
All right, thank you.
Okay, just to reiterate the timeline, Madam Chair, we've had numerous updates at this point. One was in March, which was the authorization to extend the exclusivity period to April 1st, 2026. The update that was in September was to indicate the scope of work that we have with UMass Donahue is to deliver that report by the January date that I have listed here and was discussed at that meeting, and that the data team has provided through the working group working with the UMass Donahue Institute, that we go for that deadline, which is within our scope of work with UMass Donahue.
Is the research team still involved in this?
The research team is included in the working group, as is the data team.
Thanks.
For goal number 9, we have create a 5-year strategic plan for the equity programming within the milestones here that have been listed: the Equity Works Career Hub and the Social Equity Application Period, which we have later on in the agenda to announce the results through September 30th when that application period closed. The other items that we have will be delivering the 5-year strategic plan for the commissioner's consideration. And additionally, one of the items that I have noted here is that the 77 course technical assistance and training program has been partially impacted by our current budget, and that we are looking to time that over FY26, which is June 30th, 2026, with FY27's budget to ensure that we can do the entire program for the benefit of those in the program. And so what we have is intending to have that 5-year strategic plan for you, which I'll work through the chair for a future agenda item.
Thank you. Commissioner Rice. Sorry.
Thank you, Chair. Mr. Executive Director, I actually had a question on goal 8B, if we could go back one goal around open data. I'm wondering if we can bake in, and I completely understand it's, budget dependent, but something that I've been advocating for many years that I'd like to see is more robust open data around testing. And so right now we have anonymized potency not in real time or not close to real time. So I want to be really aspirational here around testing to have de-anonymized not only potency, but pesticides and pathogens. So the entire microbial not in real time or not close to real time. So I want to be really, for many years, that I'd like to see is more robust open data around testing. And so right now we have anonymized potency not in real time or not close to real time. So I want to be really aspirational here around testing to have de-anonymized not only potency, but pesticides and pathogens. So the entire microbial testing on all, like Connecticut, for instance, I talk about Connecticut a lot. At the, click of a button, you can have a certificate of analysis for every product in their marketplace, which shows microbials, shows pesticides, shows potency, who tested it, when it was tested. I think we need to aspire to that place, not a CSV file, but again, budget dependent, right? But I'm hoping we could bake in language where we have de-anonymized, real-time testing data for the world to see. Thank you.
Can I raise a question? Is it an additional expense or is it just? See, that's why I don't, and this is actually obviously making sure that we act transparently. It's my understanding that, we have on a number of occasions been less than transparent about sharing some of the data that we collect. And I believe we've even kept some of the data, from of our internal staff. We're supposed to be doing some of the work on this, and that, moving forward, we're going to have to make sure that we are transparent. We share data openly so that people can protect themselves, so that we can hold people accountable, so that we can find information and trends that we can act upon. One of the issues that I received some information about, inversion and received an SOP suggestion from a licensee that actually I'm not sure if the executive director received that, but I'd like to share that with you because I'm not sure if that's going to take any more money, but this is a potential growing public safety issue, public health issue, but also, there may be a number of unregulated products that are coming through our system that we're not necessarily able to track. So anyway, I'll put a pin in that here, but I would like to talk about that at a future meeting because I do think that this is something that might be a more simple, cost-effective way to improve our access to information and data so that we can protect the public's health and safety.
Thank you, Madam Chair. I think to both of those points, I will need more information on the point of the chair, but as it relates to Commissioner Roy's point about adding additional open data around testing, that is certainly within the goal. And I would note that for the majority of these items, again, anything that we are doing in the open data platform, for the most part, given our current IT platforms, requires a significant amount of manual work from our data team. And that is why we've hit a bit of a bandwidth issue in that, in relation to that. And that's why we're looking for, in upgrading these systems or replacing them, that automation in that reporting that can go directly to the open data platform will allow us to significantly increase the capacity of what we can add to the open data platform.
Great. Any questions, Commissioner Stebbins, Roy? Okay, so we can move to the working group sponsor updates. And it would really be good because we've had, I'm sorry.
I just had,
I'm sorry.
Nope, let me just finish.
I totally hit it.
Nope, no problem. And this one I think tees up as well some of the things we may discuss. So number 10, regulatory modernization. And within that, we had discussed with Commissioner Stebbins potentially a meeting in the fall here to go through what have been a list of items that are commissioner priorities for cleaning up existing regs dating back to the beginning of time is a phrase that I like to say. Some of the initial regs, issues that have been headaches for the industry, staff, et cetera. We also have a list of items within I&E, headed certainly by advertising, which has been a headache for their enforcement, and certainly a headache that we hear in the industry, but many other items that they would highlight for your consideration. Legal as well has a running list, and we've heard quite a bit from the industry through recent formal and informal comment periods. So regulatory modernization, I think, comes here in terms of The plan having been at the end of the social consumption regulatory period to then open up what would be a modernization process. I think within that as well, one thing I would highlight, which I highlight here, is that obviously there is a House bill that has not necessarily been taken up by the Senate at the moment, to the best of our knowledge, but that would have quite a few implications of what commissioners may then also need to do on the back end of a statutory change with regulatory changes. So, in a no movement on a House bill perspective, I think there's quite a bit that we would be prepared to discuss at a future meeting to talk about how to clean up some regulations that would benefit the industry, the commissioners, the staff. But I think as well, we have to be prepared should any aspect of that House bill move forward.
One issue that I'd like to raise is when we talk about opening up reg, I think that there should be an ongoing process. I don't know where the sort of opening and not opening, and I understand we do have some bandwidth issues, but, it's my understanding, when the commission was being stood up, they were able to leverage a number of attorneys, from different walks of life who actually helped draft and support, obviously with the approval of internal staff and with the commissioners. But I would like to see what we can do so that we can streamline the process, make sure that we are constantly in the process of reviewing regs, because we have so much work to do. The social consumption, the analysis of this began, it was prior to my being appointed in 2022, it's 2025. And so we need to figure out how we can streamline the process, the hearing, the intake, to be able to draft and to keep the promise, both in terms of things like social consumption, but the promise that we need to keep to the businesses, that we recognize that we overregulated when we launched the commission, and that now we've sort of recognized that many of these stringent regulations in today, the 3-day waiting period, that many of these regulations need to be relaxed because we understand how this more mature industry is functioning. So anyway, I'd love to have that discussion in the future to see how we can leverage outside support to supplement the work that our legal teams are doing, so that we can move the ball faster. So anyway, just raising that as an issue, but that will be something I'd like to be able to do.
Great. And then as well, number 11 was separated in terms of social consumption regulations. The promulgation process was approved on July 29th, 2025, and various submissions to the Secretary of State are referenced here. Next steps as well, what I'm happy to get into, and I'll be prepared to when the commissioners come back to social consumption, is to talk about what a timeline may look like for implementation after regulations are complete. And we'll also discuss that in the context of working groups, which we have later on the agenda, as there are some working groups that we would look to create as we get to the end of promulgation. The final one, in terms of organizational structure, I have reviewed quite a bit at this point through 6 months in the role, and there's quite a few things that I would certainly like to be having discussions on with commissioners as we move forward. As of right now, I think we are looking at trying to envision how we will get through the current fiscal year with the resources that we currently have, and that has certainly delayed my ability to implement some of the changes that I would like to discuss with you. But I've tried thoughts here for your consideration. And then just within this document, again, I then tried to indicate anywhere where workflow based on our current budget has been either delayed or reduced, and then also anything that has needing to be prioritized, how I've approached that, and certainly looking for feedback from commissioners either here or in the future on that. I note the hiring freeze, and I note some areas where we would be seeking additional funding, which I believe will come back at a future meeting when we talk about a potential supplemental budget appropriation. And then Appendix B simply just indicates many things that we do outside of these 12 goals, which is sort of the core functions of each of the departments. That is not groundbreaking material, so please don't feel like you have to read that. It is covered within the annual report, but I just wanted to kind of make sure that anybody looking at that document understands that the 12 goals are not the universe of the work that our staff is undertaking, that we have the core functions, and some of these goals are to improve those functions, and some of them are aspirational about adding to those functions. And so I'm happy to answer any questions, obviously, but felt like this would be a good opportunity to discuss.
Commissioner Stebbins, do you have any questions, comments?
Not on this segment.
Okay, thanks. Commissioner Roy?
Yes, Chair, thank you. On number 12, the creation and post of cross-department position to address tip line need and centralized external communications, the complaint resolution administrator, acknowledging we have a hiring freeze, but inquiring where this is within priority or within the queue. Just want to get your feedback from the, Mr. Executive Director.
If I may, Madam Chair.
Please, thank you. Sorry. I was short watch.
So I think, I'm not recalling if we did it in public meeting or if this was a discussion, my apologies. So I think generally speaking, the answer is we had presented this, I believe it was in March. So right now where we are is the punch list items of the workflow for the position, and that the position may be required. We had a good 38 conversation earlier to understand exactly where to route specific calls from external parties, whether it be to ECGC. One example, there are many others in what is a relatively wide mission of the organization. So a flow chart that would go and accompany SOPs for the position are what the final stages are right now. Obviously, as of right now, we are not projecting to have the ability to fund that position without some things breaking in our favor, but we would intend to post the position as soon as we can support what might be an internal or external applicant, but also the hiring panel to have the final workflow for the position, the SOPs for the position, in addition to the job description, just so that everybody is clear on the expectations. So once we're complete with that, we should be good to post.
Thank you. Thank you. Thanks. Okay, please proceed. Thanks.
So that is, Madam Chair, that is the end of what I would talk about, unless there's any questions on the goals specifically.
Nope, thank you. Excellent. So on to 5 working group sponsor updates. And I have a lot of questions. So anyway, because some of that, I don't know what a lot of these are. So I appreciate your input here.
Certainly. So I did try to add, and we can make this available to the public on kind of a higher level here, but I'm just going to go through some general talking points. And if we do need to have some follow-up, I think I can work with the chair on specific updates from working groups to the commissioners at future meetings. But I try to provide some just general background here. So the Access to Medical Use of Cannabis Working Group was established May of 25. That was one of the goals that I just discussed. The lead of that group is Andrew Carter, Chief of Staff, who the Constituent Services or Medical Program reports to. The sponsors are Commissioner Concepcion and Commissioner Roy. And really the purpose of this is to provide recommendations on regulatory changes, but also potential policy changes within the program. Within that scope is vertical integration. That is certainly something that we are viewing as a priority within the organization. We know it's a priority in the industry, and really potentially discussing the removal of the vertical integration requirement. I would note that the vertical integration requirement comes up in the House bill, and so that is another thing that working group has had to try to tackle or at least consider. But ultimately, broad or really any recommendations within that medical program are within the scope for that working group to bring forward as recommendations to changes, regs, policy, et cetera. And we would anticipate those recommendations in this fall. So that group has been meeting and will need to kind of finalize their recommendations. It may be that we do that in batches. I'm not sure.
Thanks.
The Chapter 180 implementation working group, as I mentioned in the goals as well, is at a little bit more of a stage where the items that are still remaining on the task list are generally being upheld by IT infrastructure needs. But as well, there's certainly many other things that group can liaison as it relates to, again, the HCME, the host community municipal equity that we now added to a cadence of updates for commissioners in the August meeting. That is within Chapter 180 as well. So quite a bit of work, but also, that group will be ready to go when we can get some of those final checklist items with addressing the IT infrastructure. The lead of that is Olivia Coble, Director of Licensing, Facilitators Roque Rosa, who works within I&E and keeps everything moving. The delivery exclusivity working group, the sponsor is Commissioner Concepcion. The lead is her, and that will be regrouping that is led into the request that we discussed earlier to extend a report that will be coming in January 2026. Review working group sponsor is myself, the executive director. Lead is Matt Giancola, director of government affairs and policy. That was created March 2025. Really, the majority of work that's been done is trying to assess the impacts of House Bill, that should say 4206. I keep transposing those numbers in my mind. House Bill 4206 and the previous iterations that came before that. That bill moved very quickly through the House, came out of House Ways Means as 4206. Prepared to provide feedback. Really, a lot of the focus has been the way that that bill would impact the mission of this organization. So intoxicating hemp, obviously a major item that we've been reviewing. Accounts receivable as well. I believe Commissioner Stebbins referenced earlier today where metric may play a role there as an option. Ultimately, the House bill does not directly mirror the business to business or B2B model that the ABCC interacts with. So in reviewing that language, it would probably look a little different from us. So some of that feedback prepared to give as well. And then I mentioned vertical integration as well.
Director, I'd like to be added to that working group.
I think we can discuss as well sponsors throughout this. The Secret Shopper Working Group, I have a bit of an update here as well, but and I think we can obviously schedule a follow-up as needed. The sponsor on that working group is Commissioner Concepcion. The lead is CIE, and the project manager, facilitator Roque Rosa, who I mentioned earlier. Charter update was June 2025. And the working group, this is the sort of update, which I'm happy to follow up on at a future time as well. The working group has divided work into specific subgroups and is proceeding with the design of an ideal program. This is also actually referenced in the goals document. However, it must be noted that the program to be fully implemented would require significant additional funding to what we have at the moment to cover several areas of the program, including but not limited to human resources, IT infrastructure, metric configurations, which is our seat to sale, additional fleet, evidence room, cash management for purchases, staff planning, such as schedule revisions, bargaining of collective CBA revisions, I should say. And then just as a sort of separate update here, despite the lack of resources, the I&E team continues to perform announced and unannounced inspections, some of which have led to enforcement actions, since the commission has an obligation to ensure that products available to the public are safe for consumption and comply with thresholds established in our testing protocol. We are continuing work through the I&E task force, and staff has been purchasing post-market products for confirmatory testing purposes, enforcement actions, etc. I would note that that is a much smaller scale than we would intend to with a full Super Shopper.
And if I can take the opportunity to thank Chief Jones, because I didn't know that was happening, and apparently it is of recent vintage, which is excellent. This is something that is a major priority for me. Given the fact that this is a major priority for me, and because I do think that it is time sensitive, given, obviously we have some budgetary needs, but I would like to reappoint Commissioner Roy to be the lead sponsor of that working group.
Thank you. One final one here before we kind of talk next steps, and then obviously can come back however you'd like to, Madam Chair. So the Social Consumption Regulatory Working Group obviously is now coming to an end as the regulations are coming to an end, but we would certainly be repurposing that. So we talked about social consumption regulatory a little bit here. What I would say is obviously that group was charged with bringing back something that started the process with commissioners, has engaged with commissioners throughout the process, in addition to all the staff that's been at the table. And really, what I have here is a list of working group charters that are in development, most of which are around social consumption, and may, obviously you can balance as well where you'd like commissioners assigned to these working groups. I have a couple of working groups I would note that are not sort of set up in the same working group structure, have been ongoing ITL listening sessions.
I'd like to add myself to the ITL listening sessions group.
I believe that should not be a problem, that we only have Commissioner Roy in the most recent meeting, so I don't think that we'll have an open meeting law issue, but I'll double check that. And so we've also had to put together a group, and I only list a few participants here, but there has been it takes a village.
If I could also, I'd like to appoint myself and Commissioner Roy to the audit review group.
Okay, so I'm just updating as well what we've been doing at the moment and where I'm looking to go, which I'll come back to in a second.
Okay.
So the work that we've done to respond to the OIG and the SAO was done with a broad team because their questions were broad, and so we had to have folks from all throughout the organization. I'll talk in a second one of the responses and what we want to look to set up, which then comes back to the chair's point. We have a group that's working on implementation of 2024 regulation changes. So think more like the 2-driver rule, making sure all the I's are dotted and T's are crossed. And then we have 3 groups related at the direction of staff under the CPO, which is Energy, Director of DEI and Employee Relations for Leadership, Staff Committee, and Culture and Community Employee Resource Group. So, Madam Chair, if I may, for the items that you wanted to discuss for Audit Working Group, I am looking to, in response to our discussions of closing out the OIG letter and what we'll be closing out with the SAO, create an internal audit working group that would not only close out those items, as we have until February 26th to close out the SAO items, but the SAO will be back because they have to come back every 3 years, and it's been about 3 years since that started. So we'll see them again soon. Then we'll have an audit working group that would be in place to address future audits as well and any internal needs. And so that group would be led by Lisa Schlegel, CFAO. We would include a member of the GC's team to be the facilitator, which has been helpful through our previous processes. And so my apologies, Madam Chair, this is you're talking about this group as it's being established.
Yeah, as it's being established, obviously Commissioner Roy is the treasurer, so she's appropriate and works closely with the CFAO and the ITL listening session. So those two, as they're in formation or as they are currently structured, I'd like to be added to those.
Great. So then the other 4 that I have in development, these have been provided in draft form to commissioners dating back to August, and so are ready to go. The implementation group would really be about the IT and any processes that are being developed, but would need to be in communication with what have been 3 groups that were discussed as well with Commissioner Stebbins, who's been on social consumption from the beginning. And so what I would say is that we can discuss the way that these look. The intent of these 3 that I'll mention would include consulting teams with external parties. So where I've included, for example, CAB members on consulting team for the medical program, that was kind of our first foray. These would be much more expansive. So the social consumption for local advisory, which would be working obviously with municipalities, would contemplate having a consulting team that includes the MMA, the AGO, Secretary of State, DPH, local Board of Health, and municipal officials. A social consumption group for public awareness would include CAB member, DPH, local BOH, Board of Health, EOPS, highway, and gaming. Gaming as well would have access to and has been helping us with contemplating where we may be able to get some grant funding for public awareness, as we have no public awareness funding in our budget. And the final group would be to establish any changes to RVT, but really obviously focusing on the RVT that would be necessary for agents working within social consumption. And that consulting group would contemplate including CAB members, MBTC, which is Municipal Police Training Committee, ERS, which is more of the emergency response, Mass Chiefs, DPH, and local boards of it. So if you have, I have highlighted here, obviously, that those 3 groups had potential sponsors when we were at 3. Now that we are at 4 commissioners, happy to follow up with you how you'd like to divvy that up or discuss it today.
Great. No, we can follow up on that. Okay. Commissioner Stebbins and then Roy.
Thank you, Chair. Yeah, just to share a little bit of my thinking, we've talked about some of these groups as we've been out making presentations, and feel it's helpful to successful rollout of social consumption. These kind of expanded consulting teams as we've gone about, whether it's been the AGO, whether it's been some of the public safety folks that we've had a chance to, they've all volunteered to offer their insight, offer their expertise. I know it's a little bit of a departure from how some of our working groups have been constructed otherwise, but I think the deputy GC raised an interesting point about if we're involving some of these folks, being mindful of ethics concerns or overlapping of their responsibilities in terms of also their input into this. I think that's something we still need to build out and explore a little bit further, but I think having all these voices at the table, I think will help in the long run.
Thank you. Commissioner Roy?
Thank you, Chair. Mr. Executive Director, could you provide a little more edification around the 2024 regulation change implementation, and if it would be helpful to have a commissioner or the chair on that one?
Yes.
On that one?
Is that which one is that?
Regulation change implementation. So this is like forward-looking.
No, this is about changes that were made, such as the 2-driver rule, just making sure that everything is, all the processes are updated, et cetera. So it's
more retrospective to present, not
2020.
Yes, got it.
Not the look forward.
Which is sort of less policy and more running out as precedent, I would assume. Thank you. Anything else on the working groups? Okay, the social equity program period extension.
So this is an update more so than anything. And obviously, again, we can schedule follow-up agenda items as needed. But so the social equity program application period ended yesterday, September 30th at 5 p.m. We had 192 submissions by that deadline. The application included a notice that we would be taking the month of October to review those applications. And so I would envision us following up with an update with the commissioners at the November meeting on how that has proceeded. The regulatory updates, I just wanted to mention here, as we talked about the next round. I know the chair would like to use other language than round, which I agree with, but ultimately, the next time we're discussing regulations beyond
Area of focus.
And we're talking about potential updates to regulations, legal will certainly have some thoughts for commissioners to discuss in terms of future considerations for applicability for social equity programming, et cetera. So I think we have some good discussions coming up, but really just wanted to update for the public and the board that as of yesterday, at the close of the application period, we had 192 submissions.
And I don't know if you said it, and how many people can we support in this program?
I don't know. I can't answer that question specifically of a quota that we have to stay under. I would compare this to our last round, which was open for 4 months as opposed to 2, and resulted in 401 submissions. And what I don't have in front of me, but I can come back with, is how many of the 401 submissions were approved. So to give us a little context of the one.
Is more approval? I mean, I don't know what cost per person this is. Do we have that, or is it just it's provided, it's there, you come, if you meet the threshold, you get in? But is there additional, obviously, materials? I mean,
not necessarily. No, it's really about it's about reviewing the applicant against the criteria.
Okay.
But I can certainly compare how many were moved ahead against the 401 last year to give us a little context. But again, we would envision coming back on where the 192 goes as they're reviewed over October.
And quickly, do you have an update about how many social equity or economic empowerment provisional licensees are in the queue right now? Ballpark.
We have provided that information, and I'm happy to forward it to you. I don't have it directly in front of me, but most recently, Director Williams has been providing that information at request of EOED. And EOED obviously has been looking at their next funding round, so I can forward you that information.
And what I'd also like is the most, I mean, again, I was watching not the 100% fidelity to a lot of the meetings, so I may not remember this, but if you can also provide me how many licenses are owned by social equity, economic empowerment, and how many persons of color are running businesses now that are in commence operations.
So that would be in that data as well.
Great, thank you. Okay, I think it's a record. Anything else, Mr. director, so we're moving on. About pizza, I think, so.
Perfect time.
I know, exactly. All right, so moving to, I guess we're moving on to, there was one item, business not previously, I'm forgetting it, anticipated at the time of publication. I am going to ask our previous secretary to potentially serve in an interim role because I believe that we're behind on minutes. Would you be willing to temporarily serve, and we can vote you in today? But I'm afraid if we don't have access to that for a couple of months, that could be problematic.
Happy to. You don't need to vote me in. Happy to
Okay,
pick up the charge, but
that's very nice.
appropriate.
Because
Yeah, we probably need to vote. We do probably.
yeah, okay, all right. I will entertain a motion to appoint Commissioner Stebbins to be the secretary of the interim. I'll say interim secretary of the commission.
So moved.
Commissioner Stebbins, do you second that? Go ahead.
Thank you, Madam Chair. Just noting, which we had covered previously, that the other items are not on the agenda, so I think it's fine to have this discussion, but we would probably want to follow up with a specific agenda item on the 9th.
That's fine. Okay, thanks. Okay, and then you're going to have an opportunity to back out, I'm sure. So
Acceptance speech. No. And
get your acceptance speech ready. You know, I'll get you an Emmy to hold or something like that. All right. So anyway, so I guess that unless are there any comments or questions to conclude? Go ahead.
I don't know if I should second it.
Well,
you should second it.
I will second it. But I'm just saying, I think that you were just suggesting that because it hasn't been previously published, that we should not vote on that today. So,
I don't know that it would hold, so we would want it on the 9th either way.
okay, all right.
But in the meantime, happy to work with the GC and the team to kind of catch up on the status of the minutes.
Thank you.
Thank you, Commissioner Stebbins.
All right. With that, if there is nothing, the next meeting is October 9th. I believe it's 10 o'clock in the morning. That is going to be a jam-packed day, a very long day. Again, tentatively, the future meetings that have been publicized are October 23rd, October 24th, November 13th, and December 11th. And again, always reminding people that when we do place these dates on our calendar as a future meeting, it is tentative. It is not set in stone because obviously there was a little kerfuffle about us establishing October 23rd and October 24th to make sure that we have enough time and that as many commissioners as possible will be available to vote on the social consumption. So again, just reminding people that all of these are tentative dates and they do remain subject to change. So with that, I will, Commissioner Roy?
Yeah, I just want to comment. I'm actually grateful for the new dates because I've had an opportunity with the executive director to meet with multiple banks now. And it's really been enlightening and making me think more creatively about access to capital and a new approach and a new thought process. So actually, it's been helpful. So just wanted to note that for the record. And I just have a question. Are these all in person, these meetings?
Yes, they will. I mean, in the future, they will all be in person, but obviously they're hybrid. So if people want to attend remotely, they can.
Great, thanks.
And we may have additional meetings in November and December, depending on, our needs. So we will announce that at a later date. So anyway, if there's no further questions or comments, I will entertain a motion. Commissioner Stebbins to adjourn.
So moved.
Do I have a second?
Second.
I will take a call of the roll. Chair votes aye. Commissioner Stebbins?
Aye.
Commissioner Roy?
Aye.
We are officially and unanimously adjourned until October 9th. Thank you, everybody.
All right, thanks for watching, everyone. My name is Grant Smendelis, and this is just a broadcast of a regulatory hearing. Thanks so much for watching. I'll see you again very soon. God bless you all. Tell loves you very much.